can you please look up this site?
See if we can figure out something. Court calls the case of the people versus Ahmad Ali Beydoun.
Good afternoon, Your Honor. Laura Romer, people.
And good afternoon, Your Honor. Uwe Dahl, Supreme Court, on behalf of Ahmed Beydoun. Stand to my right. Ahmed, please take your name for the court.
Ahmed Beydoun.
Thank you. We're here for a public post conference and a hearing on two motions. If
Yes.
Beydoun may sit down.
Yes, he can too.
The defense is the moving party on both of those motions, so I believe I
Yes.
go first. I think to address the motion regarding the video recorded statement first. I have received Ms. Willenbring's response to our motion. I've read it closely twice. I don't quite understand the response and the position. First, not at issue in this motion is whether the defense shall be provided with a copy of the video recorded statement. I believe the prosecutor's office proposed that, and they're not now backtracking from that position. So I believe the defense is going to receive a copy of it. Second, the substance of the video recorded statement also is not at issue. When there is such a video recorded statement, the statute, MCL 600.21638, it applies to every one of those. The statement itself is a thing. It comes on a data carrier, a USB drive, a DVD, something of that nature. It can be a minute in length and of lightweight. It can be 3 hours in length and of great weight. Regardless of its substance, the protection under the statute applies. In that sense, the substance has no bearing on what protection to afford the statement. The exposition in the people's response to the motion of the allegations of the case, I think, is much misplaced. And third, most important, and maybe that's where the main dispute lies between the parties, under the statute, subsection 11, there's two separate ways for defense to have access to a video recorded statement of this nature. The first way of access is through the prosecutor's office by reviewing it at their office or at law enforcement offices in their possession. That's one way of getting access to it. And that's obligatory on the prosecutor. If there's a request to do it that way, then the prosecutor's office has to grant and provide that access. There's a separate way for the defense to get access to a statement like this, and that is within the court's authority to grant by court order and subject to appropriate protective conditions for the defense to actually receive a physical copy of that recording. That is what our motion is under. That's what we're asking. That's what we're looking for. The court has authority to grant what we're asking. And if it's done the way I propose, the defense has proposed, the following will happen. We will receive a copy of a data carrier with that statement. We will maintain custody and control of it. We will not copy it. We will not release it. We will not upload it to any kind of cloud service. It will simply reside in our office. It would be reviewed by 4 people for sure. The 2 attorneys, defense attorneys on the case, Mr. Beydoun himself, and our office staff of 1 person, the same person for 20 years who has been working for us. And then possibly an expert and possibly an investigator. If we were to decide,
yes. Just to cut to the chase, I mean, isn't that the crux of the matter? The investigator.
I'm not sure which part it is. If it's only the investigator, yeah. According to the People's Protective Order, the only people allowed to review the statement without further action by the court would be the defendant and the defense attorneys. And that there's no such limitation in the statute on what the court can allow and can order.
Ms. Willingbring.
Your Honor, as to the motion for the video recorded statement, I think that Mr. Doss's reading of that statute is incorrect. I mean, I think that the section 11 clearly lays out that it's defendant and, if represented, his attorney. Those are limited confined universes of people, defendant and his attorney. How we have done these previously is that these protective orders are signed, and if defense wants an expert to look at it, an investigator to look at it, we would then need a new order to add that person. Also, the limiting language does include display. So who views that, who that video is displayed to, not just who is holding that video. I think it's telling that defense and defense attorney are specifically identified at the exclusion of defense expert. It could say defense expert. The plain language of the statute omitted that and didn't say that, at the exclusion of that person. So if the crux of defense's argument is that they want this person, well, then this protective order that we provided could be signed as it is, and then once they identify an expert to look at it, a new protective order adding that person could be placed on that protective order. We would be happy to review that. We've done them before, and we normally agree to it. But I think at this point, we're just talking about more people that are going to be viewing this, which I think violates this statute and potentially violates the.
Well, but defense counsel, I understand that's what it says in the statute, but I mean, there are going to be portions of defendant's office that may or may not see it or have access to it.
Sure.
Right? So there might be a paralegal, for example, that is used. And what you're saying is that they would need a separate order for that?
I don't think that's necessarily true, because under the ethical rules, is a paralegal not part of your law firm and part of your defense attorney?
Right.
Yes.
And so as I understood the motion, it's not, and Mr. Dawson, maybe you can, it's not an investigator per se that you're looking at doing this, so that, you know, the offices have investigators attached to their office that have been kind of held to be part of that defense team.
Sure.
Is this somebody who the defense anticipates hiring?
It would be, yes. We do not have a standard investigator associated with our office, not the way the court describes. It's simply a matter of reviewing the statement first and then seeing what comes of it. Even the decision whether to hire an expert and have an expert review the statement, I think, should not be, we shouldn't have to ask for that, because it's within the defense counsel's provisions what to do with evidence. I hope I answered the question.
Yeah, you did, but I mean, there's a balance here as I see it, as I read the statute, a balance on limiting who has access, right? And certainly not interfering with defendants' right to pursue their defense in a way. What is defendant's objection to handling it in because I've seen it handled both ways. I've seen it handled where the expert is just named as part of that group. And I think you attached a motion or an order that I signed that did that. But I have also seen it the way Ms. Willingbrink describes it, that it limits it, and then when defense gets these other people, they're not always necessarily an expert, it might be an investigator, it might be somebody else, but an expert of some type. Then they come back to the court, and I don't think I've ever had a hearing on it. It's usually just a stipulated order that adds that person once you know who that person is.
I understand the question. And I think the objection from the defense would be that the process office is not entitled to know if we even consult with an expert about an item of evidence. That's why I propose, instead of asking for formal order, revised order, to just notify the court of who our expert is if we decide to even employ one, which at present is an if. I don't know that that's going to happen.
So what you're saying, I'm sorry, Ms. Murray, what you're saying is included in the order, but prior to the expert viewing it, the court would be notified.
Yes.
Your Honor, but my question to that is that offices that have a different system that I said we could move to the system where you have to make an appointment with our office, then we would know that information. We would know who's coming to our office.
I disagree with that because
How?
the only people that the process office has to accommodate if the review is at the process office is the defendant and its attorney.
And so you would never receive a copy in this case, in that situation. Your expert would never receive a copy.
That's not true. It is the second way of getting access to it, and that's by asking the court for an order to provide a copy of it to defense. That's a separate way of getting access to the state.
Correct, but the court is not doesn't have ownership of that file, and it's also not subject to discovery rules. So the court can't order us to turn it over if that is our process.
No, the court can't. Under the statute, the court simply has the authority to provide a copy of it to the defense or have ordered to.
They may, it's not that they shall, the court can, but the court is not required to.
Why in the case that Mr. Doss, I guess what I'm worried about is that there's not on the people's part a uniform procedure for how these are going to be handled.
I mean, there is currently, Your Honor, in that we have this stipulated protective order that we have used now for the past, I don't know, the past since I have been in this unit, so August at least, and that has never not been signed. Once that protective order is in place, I then release it to defense attorneys, or a copy is provided if it's on a disk.
I guess I'm still at a bit of a loss as to what is the people's great concern here. I mean, because I can't see a circumstance that defense counsel is going to be in any way attempting to try to violate the protective order. I just don't see that. So anybody that becomes part of the defense team is also then subject to the order.
I guess if that is how you view it, I just think that
I think absolutely. Yeah. I think both. I think that's certainly the intent of the statute, and certainly in terms of the ethical rules, they're bound by the same thing.
Sure.
So
I think that in my experience with other defense attorneys, when say they have an expert, they're wary of this statute, obviously, because it penalizes display with a misdemeanor, inappropriate display with a misdemeanor. So I have always had defense attorneys say, can I show it to this person, or can I do this, or do I need to do a protective order? So defense attorneys erring on the side of another protective order to ensure that they are not improperly displaying this video is what I have experienced. I don't like Mr. Doss's suggestion that ex parte communication is appropriate and that the court can just order something without the people's knowledge. Like, that doesn't feel
well. I don't
correct.
I don't think that that's what he was saying. I think what he was saying is that an expert, and this is at least how I viewed it, and maybe it wasn't what he was saying, that the expert would be included in the order, but also included in the order that prior to any display to the expert, the court would be notified that they have an expert.
Yeah, I think that is what I said, but if that was not, he's saying that he can tell the court without telling the people about changing the protective order, essentially.
Well, no,
or adding
it wouldn't change it.
Because those people are included.
Right, because those people would be included, but the issue, at least as I see it, is they're not sure that they're going to hire an expert.
Yeah.
So I think what Mr. Doss is saying is, we'd like to have the order cover an expert, but we don't know and haven't made a decision because we haven't seen it as to whether or not we're going to hire an expert. if we do hire an expert, decide that that's the path we're going to take, that we don't have to notify the prosecutor that the people that we have hired an expert or even consulted with an expert. But if the issue is the protection and knowing to whom it's displayed, that there would be a notification to the court that they've hired an expert. That's what I see.
Exactly the position we're taking.
Yeah, that's what I'm hearing from him. And I don't know if you had a different impression of what he was saying. It wasn't that the court was going to even attempt to be involved in it. It was just the court for the purposes of notification. So that, let's say, that person then improperly displays, we're going to know who it was.
But the people won't, unless the court informs them.
No, if
right?
if there is, then to the extent that the people would in any other way know that there's an improper display, but then you have to figure out who did the improper display.
Yeah.
The court would say, this is the person. This is who it is.
Okay.
That's, at least as Mr. Doss is explaining it, that's how I see what he was saying was going to occur.
Yes, it is.
And that the protection is, I mean, it's what I think that your reluctance may be that this is somehow going to go into some secret judicial shell. It wouldn't. And should the people argue that that person may have improperly displayed, that person, and that would be part of the order too, that the court would then disclose who that person is to the people. So you could pursue whatever avenue you wanted to pursue. That's the way I would see it working.
So I'm just curious what your honor suggests as far as the language of, are you under the thought that then the language of the people's proposed protective order already covers what Mr. Doss is saying, that any like expert that they hire is already covered by defense?
No, I don't think that the order that was proposed, as I see it, I don't think it covers that.
Actually, the people's order does not. Ours would. Ours does.
The order that Mr. Doss has presented to the court is really fashioned on the other order from, I think, 2022 that I had signed or something like that.
Actually, and I'm right.
Right, which I think was based on a less updated statute.
I'm sorry. Lest we get confused.
Okay.
Exhibit C, the proposed stipulated order that I submitted, C is working off of what was
With what you're working on. Okay.
The latest.
Gotcha. Let me get to the right. Do you have my file? My green file on this? Because I don't have it. I'm operating off the court file. And so you're referring to your paragraph 8.
That's the notification provision.
Yes.
Yes, and I took note of the court's request that if there was such a notification, that we should make it prior to the expert review. That's currently now expressed that way, and it should be added. I believe that's wrong.
Yeah, I mean, I'm just going to state for the record, I understand that your honor will make a decision, but the people are just adamantly opposed to that ex parte communication. That I don't think that gives us the information that we need. And then how would we know if someone, I understand that like we could, I just think we're going to have much less information about a person potentially viewing this in violation of a protective order from the court if we have no knowledge of this person. That's why we ask that people do these for protection of and try to follow the statute. And I just think that usurps that purpose.
Well, hold on a second. Let me, and maybe you have a slight point. Is your objection that the people would know that there is an expert or the name of that expert?
Knowing that there is an expert, that we even employ one to help us understand the evidence. That is a piece of information that the opposing party is generally not entitled to.
I don't see how that is true. I guess I don't see how that we would not be, in this case, involving a piece of evidence that is not subject to the discovery rules, how that is correct.
As if, let's say you employed an internal, you had somebody on staff that you considered an investigator. And the order specifically lays out defense counsel's investigator. How is that any more damaging to the defense than notifying the prosecutor that we have this other person?
Oh, I'm not sure I understand the question.
Well, what I'm saying is, what I understand that there may be this issue of not being entitled to know everything that the defense is doing. I get that. And I fully understand that. In this sort of limited type of circumstance, what would be the concern of the defense that the people would know that you consulted an expert?
Decision to hire an expert conveys a need, a professional judgment of even doing that. And that is essentially in the nature of a work product. That knowing that aspect is something that the opposing party is not entitled to. They do become entitled once our expert becomes a witness at any kind of court hearing. Then we have to disclose who that person is and right credentials and the like. But even deciding for the defense or any party to any litigation, what expert
Okay, but let me ask you this. If you said we're going to hire an expert and it's going to be Joey X, whatever, and that's who you sent to the court. And then you make a decision, I'm not hiring that expert, right? I don't think you have to say, well, we didn't get our expert. I guess I'm trying to imagine the potential harm to defense, even in terms of work product.
Because defense also doesn't have to present me with anything. I mean, they could even put the expert on a witness list and then decide never to provide me with anything and never to call that person.
Right. I get that. But I guess what I'm getting at is I can understand sort of in that I'll call it sort of that investigative phase of everything when the defense is getting the information and trying to analyze it, trying to do whatever. Not disclosing who it is, right? Who is doing my investigation? Certainly, I see that. I'm having a little bit more difficulty seeing an indication notifying the prosecutor that we've notified the court that there's this other person.
Yeah. Now in this discord, it becomes clear even to myself that with regard to the investigator, the concern would be both that we hire one and who that person is. With regard to the expert, there the bigger concern is to even disclose the decision of hiring. Eventually, we would have to disclose to the prosecutor who that person is. That's not the concern, but the decision to hire an expert is really rather an important one to the defense or any party to litigation, and it's not one to be disclosed unless it becomes.
Okay, so then how would let's say there's been some impropriety that occurs.
I'm sorry,
Let's say that there's some impropriety that occurs. How would the people know where to pursue that?
well, there would have to be some evidence of an impropriety in the outside world.
Right, but that sometimes that can be two things removed and they're working backwards. But then at some point, they can't go anywhere with that. I mean, how would they enforce or even attempt to enforce the, say, criminal sanctions of the order? Or even, I mean, I can think of ways that the court can enforce the order. But how are they going to enforce the order if they don't know that this person is even there and exists?
I hear the question and I understand the court is looking to balance the concerns of the statute. The outcome is something other than masking, I would understand. Still, I believe everybody tries to follow orders.
Well, right, but I get it. I mean, I understand everybody has to follow the court's order. I start from one end that everybody's acting in good faith, and then I have to operate on the other end saying, well, what if the worst case scenario happens? And now how do we back the whole thing up and try to figure out where everything goes?
And also, I just have concerns if the court is the only one with this knowledge, then what position does that leave the court in? Of the name of the person. I don't know. I just think that leaves the court in kind of an awkward situation if the court has been the only one who's been informed of who the expert is. And the people haven't.
Why would it leave the court in an awkward position?
Well, and then what would the people have to do if, say, we found out, say, 2 steps removed that there was some kind of improper display? We're trying to figure out who that is.
The order contains a provision that if you make the allegation that there's been an improper display, the name gets disclosed as to who it was disclosed to. I mean, I think I said that
Okay, I understand.
before, that the people are making that accusation, the name gets disclosed to the people.
Okay.
Right, and the people in turn would have to have a good faith basis for making that allegation.
Yeah, I mean, right, but I'm just saying, if the court has the court gets the name, okay, fine, court has the name. Then the question becomes if the people think that there's been this impropriety and the people would file their motion saying there's been this impropriety, that part of this order would be the court then discloses the name. I don't think the court is there is the person trying to hide anything from anybody.
Oh, I was not suggesting that. You're
Yeah, no, but the court is in this instance, and believe me, I don't like the court being in this predicament, but the court in this instance is just sort of playing that buffer between what the people want in terms of knowing who is in this group and the defense notion of saying they don't get to know everything about what we're doing.
Right. And I think there's other occasions when the court is finding itself in that position, any kind of in-camera review of.
Oh, right. I mean, I think that do I think the courts can handle that? Yes, but I don't want this to be, as I'm looking at how I would fashion it, is I'm not looking at this as being something overly complicated that basically just says, if you're going to hire it, then you got to notify the court that you've done it. I think also that I would put in there that the prosecutor gets to know that you've done it. I don't see that that we have this other person. I think it's what really would be potentially detrimental to the defendant is the identity of that person. Not that that person exists. Right?
Yes.
I can follow that, and I'm taking notes.
Okay. I mean, at some point, the defense has to, because of the nature of this particular type of information, defense has to sort of give way to get some of that information, and a lot of things that we might want to protect or would generally be protected, something has to give way. Right?
Yes.
So that's the way that I would see this working. But I think that the people are notified that now there is this other person. So that then if something comes out of it, the people have to figure out, well, that's where it came from, or this is the potential place that it comes from. They can then file a motion, file whatever it's going to be to the court saying, we need disclosure of the name.
So, Your Honor, from what I'm hearing is I think that, in fact, the people's original protective order would cover this because, like I said, the people are, I'd be willing to if they want to state their immediate staff and investigator, that's fine, because I think that's covered by defense counsel. Defense
I think you're right.
But if Your Honor is still asking that essentially they file a motion or a notice or something that an expert is going to look at it, that is already what the people do. The defense normally
I'm not disagreeing with you.
Yeah, I'm just saying, I think that we're kind of back to where we started. Like, I don't think this was necessarily needed because I'm not saying that they need to disclose all this information to us. If Mr. Doss wanted to say that an expert is going to look at it and didn't want to name that expert, okay. But I don't think that just hiring an expert is work product in the way that Mr. Doss says it is. And Your Honor did say that notice to the court would also be notice to the people that they hired a person, maybe not the name, but I just think we're kind of back at the first protective order that I sent Mr. Doss.
I'm sorry, I disagree with that. I think paragraph 8 of that says that we would have to first seek written permission from the court to have an expert witness review the statement.
Which is, I think, kind of what the court is stating.
Well,
It
no,
would be permission.
they're skipping the one step.
Okay.
What they don't want to do is have to come back to the court and ask. That's the only thing that's really happening. And I figured that out a long time ago. That's the only thing that's happening. The only thing that's happening is they don't want to have to come back and ask. They're not saying we don't notify you. They're not saying we're not going to say who the name is. They just don't want to have to come back and ask.
Okay.
That's that.
Yeah.
And
I want them to come back and ask.
I know.
Okay.
And I'm trying to split the baby. I'm saying they don't have to come back and ask, but you get to know. Because, I mean, if they said they were going to hire, I mean, folks, the cold-hearted reality is if they came back in and they filed a motion saying, we're hiring an expert, we want them to do this, and the people objected, I'd have a hearing. They'd probably get it that the person could see it.
Agreed. It's just about communication with the people, which I don't think Mr. Doss doesn't want to tell me if they hire an expert. But so can I just ask what Your Honor is suggesting as far as language then to address that? It doesn't have to be on the spot, but I'm just
yeah. Hey, you come up with an order. You in the black robe.
No, because that the language would read that if defense employs an expert, they need to notify the court that they do so.
They need to notify the court of the expert in the name. They need to notify the people that they have procured an expert. The only distinction in the two is the name comes to the court, but notification that there is an expert goes to both the court and to.
Same would be true for the investigator if we were to hire.
Yeah, same thing. I mean, well, an investigator. an investigator's in a different posture, I think, because that investigator gets, under the ethical rules, certainly, and under other things, gets cloaked with defense counsel. I mean, Ms. Willingbrink, what would you be your position? I mean, we've been talking about expert, but what would be your position in terms of an investigator? You think the same thing? I mean, because usually the investigator becomes part of the sort of that defense team that's going to be covered by the attorneys. I mean,
Yeah, I mean, I think like I said, in my experience is that normally defense attorneys ask me specifically if an investigator can view it because they're afraid of criminal penalties.
right.
So that is kind of where I stand on that, is like, I think it could be included. I just have concerns, like, say you hire one investigator and they watch it, and then you hire another
Other than
investigator,
this, right.
and then we're going into infinity having people view this.
Absolutely. And that's why at the very beginning of this hearing, one of the things I said is when one has an investigator in the office, they're like part of that whole, whether named or not, they're part of the whole thing.
Yeah.
I think when you have these outside investigators coming in, you know, as I'm kind of analyzing, when you have these outside investigators coming in, they're very similar to the expert. They become more like the expert than they do that sort of in-house investigator.
Sure. Okay.
And that's, I mean, if you think I'm wrong on that, that's fine. But I mean, I just see them fitting more into that category than into the other category.
I am not thinking for this one. I had a suggestion to Mr. Burnley's concern about the hiring of serial investigators. We can limit the order to one. And
Investigate. Okay.
and if we wanted more, then we have to come back and ask. I think with the notes taken by both counsel for both parties, I believe that Ms. Burnley and I went back and drafted the order we could get that done. I do have.
You think, or are you guys going to leave here and fight, and then ask me to remember?
Well, I'm not.
And after me to
but
ask me to remember this wonderful day.
I mean, I will redraft the order and send it to Mr. Doss, fixing that part only.
Yes. And here's what it is, folks. I think you understand what I've said and where I think we can try to go with this. And maybe in the future, we can look at a different process that kind of accomplishes the same thing. But for the purposes of this, let's get the order drafted. If you guys run into a hiccup regarding it, what you can do is get to Ann, arrange a time. We can do a call. We can do whatever to try to straighten out any tweaks in the language or anything. But I think I made what the court's position is clear.
Very good, and thank you. I do have one last concern about the differences in protective orders, and that was the point in time when the defense would be required to dispossess itself, basically delete or return to task the copy of the reported statement that they have. There's a major difference as to the point in time when they could have Burnley's order says conclusion of the case, or some other language that's well before the case is actually concluded. That's our concern.
How about conclusion of defense's role in the case? Because my response to that was that oftentimes it's not the same defense attorney who's doing a direct appeal, and they cannot, under the statute, give that CAC to defense. Right. So at defense counsel's completion of the case, completion of work on the case.
I like
that. I mean, yeah. I mean, I think that's yeah.
We can
work that out. Okay. Okay, we have that one. Next one.
Next one is, I think, much more straightforward, I believe. This is
really, I thought that one was much more straightforward, but go ahead.
I'm sorry. The second motion is a very limited one. We're asking the court to modify one single particular condition of Mr. Bedun's bond, and that is regarding internet use. Right now, there is a blanket prohibition of any use of the internet. I think the pre-trial release order says no use of internet for any purpose. I have laid out in the motion that that is very broad and it's life crippling, and it should be more limited to the alleged wrongdoing in this case. There's no dispute that the case does involve the use of very small aspects of what is the giant infrastructure of the internet, and that being the use of social media and the use of online communications. There's nothing wrong with prohibiting those aspects, and we're asking the court to do that. But beyond that, use of the internet is a life necessity, and it's crippling for Mr. Bidun and other circumstances. Internet use means access to medical information, medical care, medical records. It means access to almost every aspect of employment, from the searching for work to the applying for work to the training to being interviewed for work and then doing work itself. Almost all of that requires internet use, and at present, Mr. Bidun is precluded from all of that. The standard for this particular bond condition, I think, is in 6106 D2O. A bond condition has to be reasonably necessary to ensure the safety of the public. And in this case, it's not necessary, it's not reasonably necessary to prevent Mr. Bidun from the use of the internet in its entirety. That's the defense's position, and we would ask the court to.
Why wouldn't, especially given the circumstances in this case, wouldn't it be incumbent upon the defendant to come to the court and say, I want to use the internet for this particular purpose using this particular avenue of the internet?
Because there's just so many of them.
Except that, as I understand factually in this case, it really is the abuse of the access to the internet that causes the problem. I get what you're saying, that in terms of medical care and those kinds of things, but if, let's say, his healthcare was through Trinity, and he says, and there's an order that says he's still precluded from using the internet except those avenues that are affiliated with Trinity Health. Why isn't that feasible?
Because we may be back here every other week with another aspect.
I'd enjoy seeing you. But really, Mr. Dubs, here's the problem. The problem is, and I've run into this circumstance with other cases. The internet becomes this. I mean, first of all, a description of what the internet is sometimes can be problematic, right? So, and what's going to constitute, a certain type of website or a certain type of whatever. Okay. How do I know, when I look at what's alleged by the people to be the facts in this case, that if I said, okay, he has access to the internet except, say, through the avenue used in this instance. What that then does, if I did something as simple as that, because that would be the one that would be most closely tailored to the events, the facts of the case. He gets on the internet, uses another avenue to do the same thing. Allegedly. But I mean, then I haven't done anything except blocked one.
There's other aspects of the pretrial release order, the bond conditions, that would prevent that. There is a condition of not committing any crimes. There's a condition of not having any contact with the complaining witness in this case. Not a condition not to go anywhere near her location, her home.
But I'm not saying if it's her. I'm saying, what if it's some other victim? I mean, part of the pretrial conditions are protecting from that also.
There is a condition of not having any contact with minors. I think in aggregate, all of those are quite protective of the public and don't require exclusion of internet use. I thought of it this way. The internet is infrastructure, just like the public roadways. Somewhere in the allegations of the case, Mr. Bedun made use of the public roadways. And yet we are not prohibiting him from doing that in the entirety. We are prohibiting him as a bond condition from driving to the complaining witness's home.
Well, if I take your scenario, I'd say, okay, he's using public roadways to commit all of these heinous crimes. And that's what he's doing on roadways. I'm not sure which roadway he's on, but he's on these roadways doing it. We catch him. My bond condition would be you're not using any of the roadways. Then if you come to me and say, well, I've got to get to work, then I'm going to give you a specific roadway. And this is the only one you get to use. I know you didn't like me turning your story around, but
I understand.
I mean, what I'm saying is I get what a hassle that can be if you could not climb onto the internet. I get it. But also what I would understand is that there would be certain sites or certain places that he may want to go onto the internet. I am hard pressed, given the facts that have been laid out, as I'm to understand this in this case, to give him just access to the internet.
That is not what I'm asking. I had proposed to prohibit what I believe is the questionable use in this case. And I laid it out in the motion. The language is no use access of any social media, no use access of any online dating platforms or applications, no online posting of any content, and no communication through any social media, online dating platforms or applications with anyone. That already is much broader than the allegation of the case.
And there's the danger. Because I get these sites, I think people know what dating apps are, but I get these sites that are really sort of mixed. Some people may call them this, but other people are going to say that they're really social media because people are communicating either on that site or within that site. And that becomes the problem. Definitionally, it becomes a problem of did he violate the order? I am one, and I hope you guys know this, but I'll state it. I am one that wants to make it very clear what I'm ordering. Make it very clear to the defendant or whomever what you can do and what you can't do. So that then you're not coming before me saying, well, I don't know that this was that. Right? I didn't realize this was a social media platform because people aren't really doing this. I have this definition of social media platform. In these instances with the internet, it becomes much easier. And I understand the burden that it might place on defense that to say, these are the sites, this is where I want to go. I have Trinity Healthcare. I need to use this. I need to use this for healthcare. I may be getting unemployment benefits. This is a site I have to use. That way it's real clear where he's supposed to be and any place else he's not supposed to be.
I understand the court's position. I believe Mr. Bedun is listening and understanding it as well, and we will proceed that way.
Okay. Ms. Willingbring, you didn't say anything, and I didn't mean to, because Mr. Doss keeps you.
Briefly, Your Honor.
Pardon?
Just for the record, I know that the court has read my response. The people are opposed to the changing of that order based on the facts underlying this case. Also that the people are have executed search warrants and are continuing to on at least 2 different Snapchat accounts, at least 4 email addresses used by the defendant. So that's an ongoing concern because he has multiple email addresses. We use email kind of prolifically to access a lot of the websites that Your Honor even brought up. So I just have concern that really any use of the internet can't really be overseen. And obviously he has the other bond conditions like don't commit another crime, but we're here because the allegations are that that happened. So I think that people are just concerned that yes, the internet is a public roadway, as Mr. Doss stated, but that public roadway was used to commit a crime, and he has not earned access to that at this time. And I don't think that there is an adequate way to kind of oversee any usage, even limited usage of the internet, given the information that the people have.
And here's what, so that you understand what the why the court prefers to do it this way. Here's what I know. When I tell somebody don't get on the internet, that sometimes can be like telling somebody not to breathe, right?
Yeah.
If you catch them on the internet, then great. But at least this, I mean, right now, if he's caught on the internet at all, granted, that's a violation. But I also realize that I don't want to end up in a situation where he says, I was trying to get to my doctor. This is how I did it. And then he's here on a violation of bond, which would technically be a violation of bond. And maybe he should be able to have healthcare access. But then for those that are much more sophisticated in terms of looking at it, they can see whether he's been anywhere else. As opposed to those specific places that he can go. Again, I understand what the people's position is, but I would entertain specific places that he can go. And now that I just think about it, I would also entertain that that only being able to use a certain email address. So I'm not ending up in a situation where he's creating more email addresses going all over the place. Okay. And I do note the people's objection. I mean, I have some concerns myself, but
Okay.
I do in all of these cases.
Thank you, Your Honor.
All right.
Very good. Thank you.
Anything else?
Well, we have a PCC, I believe, to adjourn for discovery. I think there's at least 10 or more items still outstanding. Some of them are still work in progress.
All right. How much more time there?
Probably at least 30 days, Your Honor.
At least 30. You want to go August 1st or the 25th of July?
August, Your Honor. I'm not going to be in the office on the 25th.
Hold on. August 1st. I'm just counting out because Billing at some point is going to try to disappear on me. All right. August 1st, 2024. 9 a.m. Thank you, folks. And council, order in 14 days on both of these, please. On both of your motions.
Your Honor, as to the defendant's motion on the internet usage, these will be like specific things that they will submit to the court and include me on them?
Oh, yes, absolutely.
Yes.
Yes, and that prior to, so that we're clear, that, and how I've done this before, that he would submit where he's going, that's submitted to the people. I'm not doing anything. I'm not giving permission, giving the people adequate opportunity to object to that.
Okay.
Okay. So usually, I think in the last one I did, it was 7 or 10 days to object. Usually 7. Okay.
Very good. Thank you again.
Thank you. Time is it? Really? Why do I feel like it's 8? 14-8 stands adjourned. I don't have a Carol.